subcontracting and joint ventures. This webinar was developed with the goal to help veteran businesses accelerate their growth in the federal marketplace.
Can everybody hear us?
This is Tony Franco. I can.
Okay. Okay, great.
Okay, and that is just what VIP is all about, accelerating the success of veteran-owned small business government contractors. And it is working. On average, companies grow 63% 1 year after graduation from the VIP program, and VIP Grow graduates report a 357% growth just 2 years after graduation. VIP offers 3 different curriculums to give veteran-owned small businesses the tools they need to win government contracts. Programs are held in the Washington, D.C. area, just 11 miles from the White House. Participants receive hands-on, market-based instruction that helps establish best business practices for federal government contracting. And the program is offered at no cost. We currently offer VIP Start for veteran-owned small businesses looking to become procurement ready, VIP Grow for later stage companies already selling to the federal government and looking to scale, and VIP International, which accelerates veteran small business success in the global marketplace. This webinar series is made possible thanks to the support of the United States Small Business Administration. Its goal is to provide resources to the 22 veteran business outreach centers located throughout the country that support veteran-owned government contractors with entrepreneurial development services, such as business training, counseling, and mentoring. And there is also now a resource for the VIP alumni and applicants to ensure their continued success in the federal marketplace. I want to point out that the slides and audio from today's webinar will be made available on the VIP website at nationalvip.org. And now it is my pleasure to introduce a true leader in the field of government contracting, Tony Franco. He has over 30 years of legal experience representing clients on business, corporate, and government contracting matters. He oversees the Government Contracts Group, covering all aspects of federal government contracting, while working with business and corporate law groups on transactions in the highly regulated government contracting marketplace. Tony leads the government contracting group over at PilieroMazza, and I am just thrilled, and I'm going to turn that Tony can join us today, and I'm going to turn this over to you now, Tony, to begin the webinar.
Thank you very much. It's a real privilege to present for the Veterans Institute for Procurement. There's a lot of material that we're going to be covering today, so I'm going to go ahead and just jump right into the presentation on teaming, subcontracting, and joint ventures, which are the 3 key components of how government contractors, particularly small businesses, enter the market and then become competitive. Turning here to the first slide, which I am not sure if I have control of this machine here yet. I'm sorry, you guys. Let me just try to move it here. Okay, I'm sorry there. That was my bio that was quickly referred to, but the overview of today's presentation will be teaming agreements, subcontracts, and joint ventures, and then maintaining small business status in these arrangements, which are so important when companies enter into teaming agreements and subcontracts, and which is critical in order to joint venture. And then we will go ahead and segue into changes on the horizon that I will touch upon during the course of this presentation, because the SB just on Friday issued proposed rules that are going to change some of the current regulations that impact joint ventures in particular, but just different aspects of government contracting. So you should note that although most of the material here is going to be relevant to your future business plans for all the attendees, there might be a couple tweaks here and there that occur in the regulations, which I'm sure the Institute will keep you abreast of, since these proposed rules were just issued a couple days ago. Turning to what is a teaming agreement. It's critical for government contractors to understand that when they enter into a teaming agreement, it's because they're entering into an arrangement with another company to pursue a specific procurement or specific contract. Oftentimes we have clients that we believe they can enter into a teaming agreement to enter into multiple contracts. They sometimes call those memorandums of understandings, but in fact, most teaming agreements are very contract specific, and we always recommend that they be made that way. And they should be made in a way so that they are legally enforceable, not agreements to agree. And as you will see, that is a big problem when it comes to entering into teaming agreements, because more often than not, the way these agreements are drafted in the rush to put together a proposal and put your team together, companies are using forms that don't tie up all the loose ends. Which leads us to the next point, which is you need to be as specific as possible and clearly defining the roles and responsibilities of the parties to the teaming agreement, so that to the extent there might be a dispute in the future, the contractors to the teaming agreement don't find themselves with a situation where a court determines that what they're trying to enforce is not enforceable given the way it was drafted. And the reason that happens is because there's oftentimes ambiguity in what the parties intended. And the parties may, in their mind, know what they wanted and what they thought they were getting out of the relationship. But if there's no clear meaning of the minds regarding some very clear aspects of the relationship moving forward, not only with the proposal, but with performing the work, you can find yourself in a teaming agreement that results in award to a teaming partner, but that you, if you're the subcontractor, don't get much of the work that you anticipated. Now, the benefits of teaming, the reason companies enter teaming agreements is because they want to capture new business with another company that has the capabilities that helps them compete for the work better. That allows them to get, a greater market access to opportunities that perhaps they themselves cannot get on their own, either because, for example, if you're a subcontractor to an 8A company, those 8A contracts are 8A contracts you cannot receive on your own, or with, of course, a service-disabled veteran-owned small business. Most companies out there that are teaming with SDVOSBs are doing so because they realize there's a whole market being set aside for them. So that's why they're teaming with SDVOSBs. And SDVOSBs, in turn, are teaming with other small businesses and larger firms because they help them perform the work that they may need help performing. If there are construction companies, it helps them increase their bonding capacity. And it essentially allows the contractors, when they put together a strong team, oftentimes with the incumbent, to go ahead and better compete the work and secure the work that was being performed by the incumbent, or that perhaps the incumbent has had for many years, but they're able to assemble a team that really provides a value that the agency is looking for, because perhaps they've become tired of having the same incumbent in there. And we do hear that happen often, that clients tell us that they've heard that these agencies want to see a change in the agency. And so you need to put together a very, very good team that makes the agency feel that they are going to get a new contractor that knows what they're doing and is going to bring in new technologies and perhaps new ideas to do the work, or oftentimes just new people, because they want to see new people doing the work. So it allows companies to basically take what they're doing to the next level. Now, of critical importance to you is that the teaming agreements have to have certain key terms. And I could read the points that I have on the slide. What I'm going to do is touch on these and generally say what the most important ones are. Obviously, you're teaming for a particular contract, and so you would always want to identify the RFP and specifically a statement of work as well that you intend to have your teaming partner do. You want to make sure that the parties have thought through and negotiated what happens after contract award, because oftentimes there's just boilerplate language in these teaming agreements. And we recommend to clients that really want to be in a position, if they're subcontractors or proposed subcontractors, that they should really think about also putting together a subcontract that would be attached to the teaming agreement so that it's understood how the subcontract will look. The reality of the matter is 99% of the time companies don't do that because they're so busy working on the proposal, and who wants to put time and effort into negotiating a subcontract for a procurement that may not be awarded to that team. However, in an abundance of caution, when we're explaining to clients what they need to do to protect themselves to the nth degree, this is something they really need to consider. And if they're not going to actually have a subcontract attached to their teaming agreement, then they should think about having a very, very robust teaming agreement that lays out the terms that they agree will be in the subcontract. You also want to make sure that you have a relationship with your subcontractor that doesn't create an affiliation. And this is critical. That means that you don't have terms in the agreement that make it look like your subcontractor, if they are a large business, is in a position to control the work that's being done, or that reflects that without them, you can't do the work. So that is pretty simple to do in most cases, because teaming agreements in general are written in ways that are very prime contractor friendly. But there are ways that you can run and follow those affiliation rules, as we'll discuss quickly later on another slide. You obviously want to put in the agreement what each party is going to contribute to putting together the proposal, which normally means each company pays for their own cost, and the prime contractor incorporates the sub's proposal into the prime contractor's proposal. Of critical importance here is that the parties identify the roles that each will have in performing the work in the future. As a procuring agency may want to see the teaming agreement, and even if the procuring agency does not want to see it, there are situations that may arise where now the award has been made and it's time to negotiate a subcontract, and there really hasn't been a meeting of the minds on how that work is going to be split, particularly if the work is of a kind that 100% of it is not that distinct from other work that may be applicable in contracts where the subcontractor is going to be doing very, very specific work that the prime does not know how to do. Almost all teaming agreements have references to how proprietary information is handled, although oftentimes this has already been addressed in a non-disclosure agreement signed before the teaming agreement is executed. You want to spell out the division of work, and this is a critical part of this exercise, because this is where you come to a meeting of the minds of how much work the sub is going to get and what kind of work the sub is going to get. The other provisions here that are laid out, the last 5, assignment, termination, exclusivity, non-solicitation, and disputes in governing law, those are actually provisions that are pretty straightforward and normally enforceable in an agreement, in a teaming agreement. Unlike provisions for the award of a subcontract, which courts are reluctant to enforce if there are not specific enough terms in the teaming agreement that show exactly what the intent was. But the assignment provision just indicates that neither party is going to be assigning the teaming agreement to another company. If you're a prime, you do not want your proposed sub to give that work out to somebody else. Same thing with the termination clause lays out when the teaming agreement comes to an end, and there are very boilerplate terms out there, but we always recommend to our clients that they run those provisions by us if they have reason to suspect that the termination clauses may be problematic. Some termination clauses indicate that the teaming agreements end after a year, and if that happens and the procurement lasts more than a year, a proposed subcontractor may find that they no longer have an agreement in place because it was only going to be a 1-year teaming agreement. And procurements these days often last longer than that. There's also provisions of termination agreement in the termination clause that you would want to address concerning what happens if an award is made to your team and then it's protested. You want to make sure the teaming agreement is in effect for a period of time while the protest is decided. So these are like some of the issues we've seen arise over the years that need to be thought through and incorporated into the teaming agreement. The most common of all the provisions are the exclusivity and non-competition, with both parties to the teaming agreement agree that they are not going to go after this work with anybody else, and that they will not be competing with the other company on this contract. It's usually not a controversial one, but it's one that needs to be thought through carefully if the relationship between the companies is not that deep and there's some distrust, because once you've entered into this agreement, you've committed yourself. The non-solicitation of employees clause is pretty straightforward in that most companies are not teaming anticipating that the other company is going to go ahead and try to take their employees. So it's a standard clause. And the disputes and governing law clause basically just indicates where every dispute will be resolved, and the laws of what state will be determinative. And when it comes to teaming agreements, most states follow the same general rules in terms of what's enforceable and what's not. Now, as I mentioned earlier, one of the most critical aspects of a teaming agreement is a division of work. So you want to go ahead and normally have as an attachment to the teaming agreement a scope of work which lays out in as clear terms as possible what kind of task the subcontractor is going to be performing. And this can be done a variety of ways, either through a percentage of work, which is normally critical, but also by identifying specific areas of the statement of work that will be performed by the subcontractor, or by laying out in just a narrative form what kind of work will be performed by the subcontractor. You should know that on almost all these cases, the prime contractor will want to have the right to adjust the work share, particularly if the proposal that they get from the subcontractor does not make the prime contractor's proposal competitive. And this could get very tricky because most subcontractors do not want their pricing to be changed. So this is going to have to be negotiated and discussed early. And keep in mind that most prime contractors do have the leverage with regard to being able to keep some freedom of contract in terms of the ultimate proposal, as well as how the subcontract is at the end negotiated and signed, because they're the ones responsible for the work with the government. Where the challenge comes in is where there are sometimes prime contractors that want to, now that they're in the driver's seat, they've won the award, may want to go ahead and take advantage of that leverage. And that's why it's always critical that you've really got a good relationship with your teaming partner, and that you also have a very well-defined scope of work or division of work provision in your teaming agreement. Now, as I mentioned earlier, it's just critical that you have the right partner, and due diligence is critical. And we always can sort of sense when we have a client that's approached us, and oftentimes the other party they feel very good about, and it's just a matter of us quickly looking at the teaming agreement. But there's normally an issue which they want us to look at because there's something they suspect in the relationship could go wrong. And so what we always ask is, how well do you know this teaming partner? I can tell you from a recent situation I had where a client indicated that they were going to be a proposed sub, but they were very concerned from what they had heard on the street that the prime contractor had not fulfilled the commitments to other teaming partners. So they could easily walk away, but they said no, they wanted that work. They felt the prime really needed them, so they were not likely to get the short end of the stick. But they also wanted us to make sure that the agreement was very tightly written. Now, that's the case where the client knew exactly who they were going to be teaming with. We have many situations where that does not happen. Also, it's critical that you think about getting certain representations and certifications from your teaming partners. If you are a proposed subcontractor to a service-disabled veteran-owned small business, for example, you may want to make sure that if you're going to put time and money into teaming with them and then putting together a proposal, that they actually are a small and meet the socioeconomic status that they claim to be. The same thing, by the way, for a prime contractor who is now going to be teaming with another small business. And in the case of, for example, service-disabled veteran-owned small business that may want to team with another service-disabled veteran-owned small business and wants to use that other company's size and status to demonstrate that they are entering into an arrangement with another similarly situated company to meet the subcontract limitation rules. You want to get some, very, strong representations and certifications on their status. And you may want to go beyond that and verify. I will say most companies don't do that because it can take some time to verify a company's status. And a teaming partner is just not going to give you all the information they may give to the VA or the SBA in connection with a review of their status. But that doesn't mean that there isn't some level of effort that you can engage in to determine whether the company is legitimately what they say they are. Now, one of the things areas that we are normally very busy working with our clients on when they're teaming is making sure that they do not violate the ostensible subcontractor rule. And this is basically a very, very popular size protest ground where a competitor who has lost a contract to an awardee basically makes allegations that the relationship that prime has developed with their proposed subcontractor violates this rule and creates an affiliation. Now, you should note that this is really a big problem for small businesses, and of course, SDVOs, 8As, WOSBs, whenever they're teaming with a large business, because you do not want to be affiliated with them. That would disqualify you. And what the SBA looks at, if such a protest is filed, is whether it looks like the subcontractor is going to be performing the primary and vital requirements of the contract, or whether the prime contractor looks like they may be unusually reliant on the sub, which is one of the reasons it's important to draft the joint venture, the teaming agreement properly, and then be very clear in the scope of work, because you do not want to be giving a scope of work to your subcontractor who's a large business, what looks like the most important part of the contract, or at least the most key positions, such as project manager. And for example, if there's 5 key personnel, you don't want them to have 4 of the 5 key personnel. Those are factors that are looked at by the SBA in determining whether there's a violation of the Ostensible subcontractor rule. Keep in mind, this is a very contract-specific analysis. If a company is deemed affiliated under this rule, it only results in their disqualification for that specific contract. It does not impact the company in general on other procurements that they may be pursuing with other companies, or even with the same one if it's structured properly. And as this slide indicates, these are all the factors the SBA will look at to determine whether there's been a violation of the Ostensible subcontractor rule. But keep in mind that I indicated in my earlier slide, there's an analysis they do in terms of looking at the totality of the circumstances, which will also be taken into account. Turning to the next slide, to lessen vulnerability, with regard to avoiding affiliation, again, try not to give the subcontractor too much work. I would keep it at below 40%. Many companies assign percentages, but don't just indicate in the team agreement that they're going to do 30% or 40%. Be more specific. And keep in mind that, again, if you're in a relationship with another similarly situated entity, this is not going to be a problem, because the Ostensible subcontractor rule has been deemed to be exempt for similarly situated entities. And keep in mind also that if you're in a joint venture, the 2 companies in a joint venture would never have this rule applied to them. Although a joint venture could be deemed affiliated with subcontractors to the joint ventures. So for example, if 2 small businesses create a joint venture and they bring in a large business sub to do the work, there could be application of the Ostensible subcontractor rule in that situation. Now, turning to the subcontract, once a company has received an award, the one thing they need to be thinking about is how are they going to draft the subcontract for the particular procurement in question. Like teaming agreements, there's a lot of template subcontracts out there. And what I hope that you can get from the slide here is the most critical elements of any subcontract. You normally want provisions similar to those in the teaming agreement, particularly if the teaming agreement is one that reflects that the parties really rolled up their sleeves and negotiated many subcontract terms, so that all you need to do is look at the teaming agreement and see that you said, okay, we're going to do this way, this way, and then you incorporate into the subcontract. A critical element of every subcontract also is how much work will the subcontractor be expected to perform. If you're a subcontractor and you teamed with a company that's received a 5-year contract, your expectation is that you're going to do the work for all 5 years. But if you're a prime contractor, you're going to perhaps want to have you're going to want to have the liberty of having the same rights to exercise the options for the sub that the government has exercising options for you. Of course, there could be friction there, because the subcontractors will say, no, we will only agree to this in the situations where the subcontractor has gone ahead and put together a provision in the agreement that provides for, I'm sorry, I have a phone in the background ringing, and I'm going to shut it off so it's not bothering everyone. There we go. I'm sorry. I apologize for that. And so what I was saying earlier is that in situations where a subcontractor has insisted on wanting to do the work for the entire period of time of the original prime contract, they will insist that there's a clause incorporated that provides that whenever the prime, the government exercises an option or makes a modification, that those will flow through. And in most cases, those are provisions that companies agree to. The other thing that's critical is going to be the delivery schedules, in terms of making sure that the subcontractor knows that they may have a delivery schedule that's tighter than the one that has been imposed on the prime. And in part, the reason for that is because you never know what deadlines the government is going to be providing to you as a prime that requires that you plan ahead with your subcontractor. So normally when we're drafting subcontracts for our clients, we shorten the period of time that the subcontractor has to do certain things to give the prime contractor time to review, for example, deliverables, or also if there's a need to submit reports or notify the government of problems, that all these things are run by the prime in advance. Also, you want to make sure that there are flow down provisions of your prime contract into the subcontract, because you want the subcontractor to do everything that is also required of the prime. Additionally, one of the things you want to lay out is the program manager's roles and who is supposed to be speaking with the agency. And again, just like in the teaming agreement, you want to make sure that there's some clarity as to what can be assigned to other companies and whether lower tier subcontracting is permitted. And lastly, the changes in disputes clause. In every subcontract, it's normally a provision that lays out how the parties are going to deal with mods that are imposed by the government normally, and then what happens if there's a dispute. Because oftentimes the prime contractor does not have a dispute with the government, but something the subcontractor has done on the contract could result in a dispute, which the prime contractor may agree with the sub, given perhaps interactions between the government customer and the subcontractor, which happens more often than not, but that now has resulted in a dispute where the subcontractor has no right to go directly to the government to resolve it. And we recommend that our clients go through the trouble of really negotiating what will happen if the prime contractor has to sponsor a claim for the subcontractor because there's a dispute with the government. And of course, there's always a potential for a dispute between the prime and the sub. And the parties have to decide whether they might want to engage in arbitration, for example, or if they want to be going to local courts to fight certain disputes. And we have our own opinion on that because, as it is, arbitration can be expensive, and we see a lot of subcontracts that provide for arbitration. But that's really something that has to be negotiated between the parties, and there are pros and cons in both. Now, with regard to personnel and performance, this is one of those areas too that it's critical that in every single one of these subcontracts that the parties have identified exactly what is going to be billed, and also who are the people that are going to be performing the work. And most prime contractors are going to want to be in a position to essentially tell the subcontractor when they need to remove people. Now, usually the prime contractors will not want that right unless they realize that they may be subject to it as well because the government's imposing it on them, and they don't want to be in a situation where the government's telling them to remove a subcontractor's employee, yet there's no right to do that. But in general, the best way to protect a prime contractor in these situations is to have a provision that always gives the prime to ask the sub to remove people that they are not happy with, usually at their absolute discretion, but also giving them a certain period of time to substitute. Again, these are areas that have to be negotiated because there might be situations where you don't have the luxury of giving the subcontractor too much time to find somebody else, and the prime may have the people that can do the work. And also of critical importance with regard to these subcontracts is that the government have the right to inspect the subcontractors' work and facilities and even audits their books and records. Now, oftentimes this is handled by a prime through a provision that gives them the right to do it. And there's oftentimes significant pushback from the subcontractor because they are not going to want a prime to be snooping around in all their books and records. And they may say this is something that should only be permissible if the government demands it. again, it's one of these things that's negotiated, and we personally don't think there's any reason to deny a subcontractor the right to basically say, look, it's going to be whenever the government wants to come here as opposed to the prime. But there are situations where we could see a prime feeling that it's necessary for them to get ahead of a government audit, because you have to keep in mind that at the end of the day, it's going to be the prime contractor held accountable for whatever the subcontractor does. So it depends on each situation and each contract. But from our experience, most companies are agreeable that it will be the government that has the right to inspect the sub's work and facilities. Now, with regard to changes, one of the areas that every one of these subcontracts should also provide for is what happens with regard to changes. Because just like the government will go ahead and make changes to the prime contract, oftentimes through contract mods, and sometimes without really doing anything formal, you need to have a system in place for the documentation of changes that are imposed on the subcontractor. And this is one of the areas that we find most disputes between primes and subs, as well as between primes and the government, where there has not been a proper documentation changes of how the work is now somehow been modified. Because if changes occur, you're entitled to equitable adjustments, and those equitable adjustments should be moved upstream from the sub to the prime and from the prime to the government. And then this gets tricky when a prime contractor now has to get in the middle of putting together an equitable adjustment claim to support monies that are going to their subcontractor. But it's something that has to be thought through and put in place, because it's a critical part of contract administration for any successful government contractor. Now, another provision that is critical is the payment clause. Of course, you want to define exactly when payment is due, and the invoices procedures, where the invoices are going to be sent. Are they going to be paper? Are they going to be electronic? One of the areas that we find a dispute on subcontracts is most prime contractors want to insert a paid when paid clause, meaning that they will pay the subs only when they get paid. And there are subs that do not want to wait that long, because the government could take sometimes months to pay a prime, and that means the sub has to sit around waiting while still performing work. But paid when paid clauses are very common, particularly with regard to contracts awarded to small businesses. And most large businesses recognize them, although they'll push back. In our experience, to large businesses, they do not demand paid when paid clauses when they have subcontractors that are small, as they recognize the small businesses may not have the financial resources to wait. Among the other provisions that need to be indicated normally is how you're going to identify indirect costs and perks, travel, and what the per diem is going to be, the right to audit, as I mentioned earlier, and what will happen if the government disallows cost, which was what I was referring to earlier. The need to have a process for the prime contractor to sponsor the sub's cost if they want to do that. But if they don't, then you may have a situation where subs not fighting the prime contractor because they believe they did the work for the prime and the prime should pay them. And one of the areas that we see from time to time is whether the companies have decided to create an escrow account or some place where funds are deposited by the government to make sure everybody gets paid. Those are rare, but they do happen in certain situations when the sub believes that the prime may be facing in the future certain financial difficulties, and they want to make sure they get paid, or there's just a lack of trust. Of critical importance too, with regard to any of these subcontracts that small businesses or SDVOs enter into, is that they need to make sure that they meet the performance of work requirements. The subcontract limitation rules, which is 50% of the receipts of the contract on a service contract must be going to the small business or SDVO or other similarly situated entities. The same goes for supply contracts. The number is much lower for general construction contracts, since in construction, it's understood that so much work gets subcontracted out. And for specialty trade contractors, the number is 25%. And keep in mind that the number here is based upon total contract value, as opposed to the old rule that the SBA had, which looked at labor cost. Many government contractors out there that are small businesses are probably performing contracts right now that are under the old rule because the FAR clauses incorporated into the contract reflect the old rule. But for your purposes, and given what we're seeing, all these solicitations now are being issued under the new rule, it's based upon total contract value. Also keep in mind that there are certain exceptions as to what can be taken out in determining contract value. For example, on a service contract, whatever is spent for materials is not included in determining compliance with the 50% rule. Now, one of the things, best practices to consider is always sit in your proposal and your teaming agreement and subcontract that the subcontractor will not perform more than a certain percentage of work, so that it's understood that's the intent of the parties. And this means also the subcontractor should know that they should not be expecting any kind of readjustment, or should expect perhaps some readjustment if for some reason the amount of work that's going to the prime has diminished because perhaps task orders are not being issued at that level that they anticipated. And so now they're finding that they're doing less work and receiving less from the contract. And that may require that some of the work gets shifted to the prime. So you have to have a mechanism to reduce the sub's work share, which obviously if you're a subcontractor, excuse me, can be very problematic if you're anticipating doing 40% of the work and now you're doing 20. And you may suspect that it's just a prime contractor who's trying to just take work away from you when there may be other reasons. But this is a very solid reason why that provision needs to be into these contracts. And it also shows if you are protested on affiliation grounds that you really do want to go ahead and not be affiliated with your subcontractor. Now, subcontractor versus joint venturing. This is critical for the audience to understand in terms of the difference here, because we are seeing so many more companies entering into joint ventures. And there's a lot of good reasons for that, with all these big contracts that are being awarded these days to small business set-asides and SDVO set-asides, that these contracts really cannot be performed by one company. So companies will team or they will joint venture. And one of the things to keep in mind is the reason companies subcontract versus joint ventures. The differences are that, in a JV, both parties generally have equal bargaining power and say over how the contract is going to be performed. Now, there are exceptions under these set-asides because if you're an 8A or SDVO JV, the 8A or SDVO has to control the JV. But if you have a JV between two small businesses, the parties are jointly and severally liable. They're both responsible for contract performance, so they tend to have more or less equal say. Obviously, in a prime subcontract relationship, it's the prime who's on the firing line with any disputes with the government and ultimately responsible. And so therefore they control the relationship. Also, with regard to bonding in the construction field, JVs typically are able to bond based on what both JV partners bring to the table, usually through indemnification provisions, actually, which the JV partners make to the bonding company. With regard to subcontracts, it may work that you get your subcontractor to provide the bonding, but you have to be careful with the affiliation rules in terms of being too reliant on a subcontractor to provide the bonding, because if they're large, it could look like without them you can't do the work. One of the most important differences here between subcontracts and joint ventures is if you're a small business, prime or SDVO, and you receive a $100 million contract, and you have a subcontractor you're giving away 49% of the work, you still have to count $100 million towards your revenue. But if you're in a JV partner with another company, you only count the percentage of the revenues you receive that you're doing on the JV. So the joint ventures are often employed by companies in order to stay small longer. And it's one of the strategies we recommend on a regular basis to clients of ours that are realizing that their success is now going to potentially make them large too quickly. Now, with regard to joint ventures, you should know that the SBA's regulations actually has a definition of what a joint venture is, and it essentially involves an association of individuals, or normally companies in the small business government contracting world, that have decided to get together to pursue a limited number of contracts. And what this definition provides is what's called the 3 and 2 rule, which is a rule that basically says that the SBA recognizes that, you create a joint venture to go after a number of contracts, but they don't want you to be using this joint venture now as essentially another legal entity that is constantly doing for work. So it looks like the owners have 2 different companies and participating perhaps as SDVOs through 2 different companies. You could participate in these programs through the joint venture, but for limited purpose. That said, though, you can't create multiple JVs with joint venture partners, and you just have to be careful how you do it, because if you engage in too many of these, it could create affiliation, despite the exceptions that exist. Now, the basics of a joint venture agreement is, the main characteristics is that companies are sharing management, although there are, caveats there if you're an SDVO or an 8A firm and pursuing SDVO and 8A contracts or WOSB contracts, hub zone contracts. They want the hub zone company or the 8A company, et cetera, to be managing. But that doesn't mean the other company has no say in it. They have to, share profits and losses. And normally these joint ventures last for only a certain period of time. With regard to competing in a joint venture, you should keep in mind that these joint ventures need to be put together before you submit the offer. It's got to be an actual entity that's been created. And the agreement has to contemplate, not that you're like doing a teaming agreement, but that you're actually now laying out that you're going to be performing a contract as the JV. And this has to be disclosed in your proposal. And there are different forms of joint ventures. The most common one is an LLC. And the reason we think our clients should enter into limited liability companies is because they can be put together fairly easily, and they provide more protection than a partnership, which the SBA views as an informal joint venture, and if not properly structured, just result in both parties essentially being liable for any work the other party does, whereas the LLC doesn't. Many companies can actually form corporations to joint venture, but as many of you may know, corporations can be a lot more formalistic. You have to have articles of incorporation, then you have bylaws. Normally you have resolutions and minutes of meetings, and then of course a shareholders agreement. And somewhere along the line, you've got to put together a joint venture agreement. So it's just more paperwork. So we recommend that our clients enter into limited liability companies or form limited liability companies and just create a joint venture and operating agreement. Now, the advantages of joint ventures is the fact that the government can look at the resources of both companies to perform the work, since the JV partners function essentially as co-primes, and also it allows you to look at the past performance. That allows the government to look at the past performance of both JV partners and bring those to the table of the JV. There are rules regarding how past performance is evaluated on joint ventures. What I just described is very basic. There are some caveats to that, but most companies do joint venture because they're trying to figure out how it is that they harness their past performance in a way that is easier to sell at the prime contractor level. Joint ventures also allow companies to perform work on much larger contracts. Now, with the new similarly situated rule, and I say new, it's relative since it has been around for a couple of years, but not fully implemented until the last year. But that does ameliorate the problems because a lot of our clients were creating joint ventures in the past because they knew they couldn't do the work required at the percentages the regulations mandated. And so JV allowed them to do that. But now with the similarly situated rule, they can actually perform the work through the prime sub relationship and show the government that they're meeting the performance of work rule. The only problem there is that all the revenues then count towards the prime in that relationship. So again, if you want to stay small longer, why not create the JV? And also, as I mentioned earlier, joint venture partner can exert more control over contract performance to protect its interest. And the majority joint venture partner, in our experience, tends to be more deferential to their joint venture partner than they may be to their subcontractor. Now, the biggest disadvantage of a joint venture is that if you could be a prime, you're not going to have the same level potentially of control that you would if you're in a joint venture, since a joint venture now creates sort of like a marriage of co-equals. That said, excuse me, there are situations where it all comes down to how you draft the agreement. And I can tell you that when we're drafting agreements to make sure our clients are putting together SDVO compliant JVs or WSB compliant JVs, that in those cases you want to have terms that make everything very favorable to the company for which eligibility is critical for these procurements. Because if it looks like those entities aren't really controlling the joint venture, somebody could protest and the protest could be sustained. So like I said, there's an element of joint ventures that create equalities between the parties. If you have, for example, two small businesses joint venturing, but once you get out of the two small businesses, the parties to these joint ventures need to realize that the other entity is going to be in a position to control the JV, really no differently than if they were a prime. One of the things that you need to keep in mind when creating joint ventures is the government always wants to know who is ultimately accountable here, because these joint ventures are, unpopulated entities by law, given the SBA's regulations, and so they always wonder who do we go to? Who is the person that we touch base with, and who are the people who we know will make sure this work is being performed? And then also you need to make sure that you've kept tabs of who is performing the work, both within the JV, since there are certain percentages of work under these set-asides that have to be performed by the SDVO, and then also how will the work be satisfied on the limitation on subcontracting, because that still would apply to subcontractors. And for example, are the subcontracts going to be with the JV or with the individual parties? Another thing to keep in mind when joint venturing is you want to make sure your joint venture partner has good past performance, as you should if you're teaming with any company. We have had situations where clients have contacted us and they've told us that they lost an award because their teaming partner or joint venture partner had past performance that was bad and they knew nothing about. So this is something that should be vetted as part of due diligence. And lastly, one of the disadvantages of a JV is, terminating a JV is sort of like more like a divorce. It can be very, very tricky because both companies have put so much into the arrangement, and the government also awarded this contract to a JV involving two companies. So when one company goes away and doesn't want to have any part to do with it, it can create performance problems, and there could be recertification issues that are triggered in terms of size and status. Now, the steps to form a JV, if you're forming an LLC, you have to file articles of organization. And this has to be done early in the process if you're going to JV, because remember, you have to file the articles, you have to draft a joint venture agreement, partnership agreement, which can take weeks to negotiate, particularly if the parties really want to do it right and think through all the issues. The LLC has to obtain a federal ID number, has to register on STAM, establish a bank account. If the contract is going to be performed in different parts of the country, you may have to register to do business in other states. So it's really forming a whole new legal entity, and you have to think ahead, because when is this proposal going to be due? Since all this has to be formed and negotiated and signed before the proposal goes in. One of the trickiest areas with regard to forming these JVs is how is it going to be run? Is it going to be run by the members or by a management committee? Is it going to be run through a project manager? Which party will be responsible for negotiating contracts and subcontracts? Who will be communicating with the customer? The sources of labor? All these are things that we immediately flag for our clients when they're going to enter into a joint venture agreement. So they talk it through with their joint venture partner and then make sure that this gets memorialized in the agreement. And this is pretty straightforward from our perspective, because we've done so many joint venture agreements that we, in connection with, for example, JVs for service-disabled veteran-owned small business set-asides, make sure that we're putting the SDVOSB in control of most of these things. But that doesn't have to be the case, and this could be done in a way that is clear that the SDVOSB may be negotiating, but with the assistance of their joint venture partner. Same thing with the subcontracts. And with regard to communicating with the customer and sources of labor, that should be all laid out, because at the end of the day, when you're putting together this joint venture agreement, you're also going to be putting together a proposal. And since you're putting together a proposal, these things should have all been contemplated during that proposal development process. Now, using joint ventures for small business contracts, you have to keep in mind that both parties have to be small for the procurement individually. So that means that, if it's an SDVO set aside and the SDVO enters into a JV with another small business, in that case, as long as they're both small, that meets the small business criteria. And then you have to make sure that the SDVO JV terms reflect those the regulations require. You should note that for JVs, that any entity that is under one of these preferential procurement programs, including small business, that enters into with an SB approved large business mentor, they can go after the work. So the only time a large business can joint venture with a small business or SDVO or any one of these other preferential procurement participants is if they've entered into an SB approved large business mentor protege relationship. Now, the SBA's rule 3 and 2. I'm going to touch upon this really briefly here, but let you know that under the new proposed rule that the SBA is issued, it looks like this rule is going to go away. An element of it is going to be around in that apparently the SBA does believe that once an award is made to a company, for the next 2 years that you continue being able to receive contract awards, but after 2 years it should not continue bidding on work and be viewed as a joint venture that is still eligible. I think because of the way the rule reads, which is the 3 contracts over a 2-year period, as it reads in the regulations and you see in this slide, it suggests that you're only really limited to 3 in a 2-year period, but there are exceptions to that. And it's a very convoluted rule, but what you should just take away from the slide is that the SBA does not want companies to form these joint ventures that then take a life of their own and are now bidding and receiving 7, 8, 9 awards. They expect these companies to essentially be going after a few contracts, and only in those limited circumstances where through the stroke of luck, they submitted so many proposals early in the process that they all landed around the same time and or after the 2 years, and it would not be fair to take those contracts away because they were eligible. The SBA, when they issued these regulations, it looked like if you're in a mentor protege relationship, you were also subject to the 3 and 2 rule. However, there's SBA Office of Hearing and Appeals case law that basically says that no, that in fact, if you're in a mentor protege relationship, this 3 and 2 rule does not apply. But that doesn't mean though that you may not still be found affiliated for other reasons. Keep in mind that one of the major exceptions to this rule is that even if you find yourself hitting the 3 and 2 rule cap, or whichever one the SBA puts together under this new proposed rule, you're still going to have a situation where the SBA recognizes that all you need to do is form another joint venture. In other words, you form another legal entity with this other company. Now, again, you could go through the same process, the 3 and 2 rule, for another 4 or 5 years, but there will be a point in time where if you keep doing this and somebody protests, you could be found to be affiliated because the SBA may determine that why is it that you need to always joint venture with another company? Why can't you pursue the work on your own? Now, with regard to the special rules for SDVOSB joint ventures, keep in mind that all of these JV partners, you must enter into the agreement as of the date of proposal submission. You want to avoid, vague or boilerplate language, which we see a lot. And you could probably get away with a boilerplate agreement. The problem is all the problems you're going to face, even if it's perfectly compliant with the rules, but if you haven't thought through all the issues that could arise with your joint venture partner, who you may be enthusiastically going after the work with, but now it's time to do the work and you really didn't think through all the things that needed to be determined in advance. But the basics of these agreements is that the SDVOSB must be the managing venture, and usually that's pretty much without having the other joint venture partner interfere with the management of the day-to-day business of the joint venture. The named employee of the joint venture must be the project manager. So these are unpopulated JVs where the employees of the SDVOSB is a managing venture. And you should note as an aside that if the joint venture is with a mentor, you cannot hire the mentor employee to now become your employee. The SBA does not allow that. The SDVOSB must receive profits commensurate with the work performed, but not less than 40%. And so in a situation where you have any other joint venture partner, the SDVOSB can actually do less work than they would be doing if they were doing a prime sub. And that may be very attractive to them because they otherwise may not be able to do the work with a joint venture or teaming partner that doesn't want to do less than 50% or less than 60%. You want to be very detailed on the parties' responsibilities for contract performance, sources of labor, and contract management. And this is critical that you keep in mind that there are cases out there where the SBA has determined that these JVs are not compliant because the companies were not very specific on what each one was bringing to the table. And this is where boilerplate language can get you in trouble. A provision that has to be in these joint venture agreements is that both parties will ensure performance of the contract if the other goes away. I will say that that does somewhat undermine the reasons why you create an LLC, which is to make the LLC the frontline corporate shield from liability with regard to any things that may go wrong with the contract. But assuming both companies are there, there's no reason why the JV shouldn't be the one that is ultimately responsible to both, as opposed to both parties. But this must ensure contract performance does, I believe, raise a red flag, in my opinion, that both companies should always realize that they want this joint venture to do their work right, because the government could try to use this as a basis to claim that they can go after the individual members. Also, these joint venture agreements all have to provide that the records will be maintained by the managing venturer, but nothing stops parties from agreeing that the non-managing venture will have a copy of those documents in their files as well. For SDVOSBs under the that are going after VA contracts, those joint ventures have to be CVE certified, and the VA's requirements are fairly clear that the JV must be a separate legal entity, and you must have, the CVE must verify the JV prior to contract award. Now, the good thing about this is that you could actually have the package into the VA before contract award, and so in other words, even though it hasn't been approved prior to contract award, you may have a situation you could still be bidding on the work, but you have the risk, if you have not received the approval prior to submitting the proposal, that the CVE might not have it verified prior to that contract award, and then you've lost the contract. And so this is similar actually to 8A contracts, where an 8A contract must be approved by the SBA prior to award, which it just so happens, by the way, that under these new proposed rules that the SBA has issued, will no longer be the case if they become finalized. As I mentioned at the beginning of our presentation, as this is our last slide, just wanted to point out that the SBA is going to be has issued proposed rules regarding how joint ventures in certain respects are going to be treated with regard to, for example, the 3-and-2 rule. They've indicated also that if a joint venture actually receives a contract through a novation, as we have seen many clients of ours try to build the past performance of their joint ventures by novating a contract from another company, that would be considered the first contract when looking at application of the 3-and-2 rule. The SBA is also has looked at how they're going to deal with security clearances for joint ventures, and they recognize that you need to have administrative personnel that may be included as facility security officers in the JV. And this is important because the SBA has said they want unpopulated JVs. They require it, but you are allowed to have a very thinly populated JV with certain folks, and that's critical for these contracts that require that the JV receive a security clearance. There's a number of other things like that in the new rules. So these are the changes that are coming, but most of them actually, I think our audience here would find very favorable, because they are going to actually make it easier for joint ventures to operate and to be formed, and less burdensome to SDVOs and small businesses in general. So that basically concludes my presentation, and you're prepared to turn this right back to
Oh, thank you, Tony. That was awesome. Thank you for that excellent presentation. That was a lot of critical information, something that I know our VIPs and veteran businesses nationwide deal with every day, teaming, subcontracting, to JV, not JV. So this was quite helpful. And I wanted to share with you that we had quite a few questions that came up And I know you do a great job, and we'll get these in responding to questions, Tony. So if we could send you these questions to you, and you could get your answers back, we'll share it with everyone that participated. So I didn't want anybody to think that we're not going to get to your question, answer your question. We'll just do it in a written format in an email. How's that? Does that work for you, Tony?
Oh, yeah, Barbara, that's where we've always worked. And the only thing I would say is that we try to get back to everyone as soon as possible after, but oftentimes there's so many questions. So it may take us a week or a little bit over a week, but we will get back to everybody.
I know you will. So thank you so much. I appreciate your willingness to do that. And I just want to thank our participants for attending the VIP webinar, and also thank SBA for making this possible. Again, we hope you found this information presented to be helpful and prepare you and your company to be compliant and competitive. I would like to ask also that you take a moment to complete a very short survey that will be sent to you immediately following this program. Your feedback is always very important to us. Again, thank you, and we wish you all continued success throughout the year. Thank you again. I wanted to